So I know that standards of review are kind of confusing. That the 14th Amendment, due process, equal protection, that they're it's kind of confusing and it's a little bit abstract. I really don't think that you're going to see much of this, if at all, on the new AP exam. That whatever exam that you're going to be taking involving free response questions, I don't think I would be shocked if any of this appears. So if you're not entirely certain what this means, it's okay. At the very basic level, just understand that not every right and not every group of people in the United States receives the same legal receive the same legal protection. Like every group receives the same rights, but in terms of like suing for discrimination, that not every group or every right is going to be looked at with the same lens by the courts. So, for example, the groups that have historically been subject to discrimination and its stigma, so things related to race, religion, national origin, so those are always going to be things that the court is going to look at in a way where they hold it to the highest standards. Things like gender, sexual orientation, that's kind of in between. But rational basis, like everything else, your age, socioeconomic class, disability, like those are things that the reasoning is those are things that can change. So if you are suing a government institution because they are treating you differently because of your age, your case is not going to be looked at with the same standards or the same criteria as if you were suing because you were being discriminated against because of your race. So that's what this means. And the same thing with fundamental rights, that if you are suing because your right to free speech was taken away, that is going to be looked at differently with a different set of criteria than if you are suing because your education has been taken away or threatened. So there are different criteria and different levels of protection that the courts and like the judges will use in making these decisions. So strict scrutiny is for fundamental rights, and strict scrutiny is for issues related to race, religion, and national origin. So this handout here, the equal protection assignment, that was just a way for you to look through a couple different examples to see if you could figure out how the equal protection clause of the 14th Amendment would be applied. So remember that just like anything else that comes before the court, it's open to interpretation. So if you decide that if you were the judge and you decided that it was indeed a narrowly tailored action to serve a compelling government interest, then that's your interpretation. Some might say no. It just depends on who's actually sitting on the court. So like this first one, it's asking you identify two groups in the scenario, identify whether the case will need to pass strict scrutiny, intermediate scrutiny, or rational basis test, and then identify whether you think the policy or law violates the equal protection clause of the 14th Amendment and explain your answer. So these are all like fictional cases. So like the first one, studies have shown that males between the ages of 18 to 21 are more likely than females to abuse alcohol and drive under the influence of alcohol. In response, a state passes a law that allows females to purchase and consume alcohol at age 18, whereas males cannot purchase and consume alcohol until the age of 21. So let's figure out the two groups that we could say that, most of this is dealing with gender. So like male and female. You can also say it's relating to age if you really wanted to. If you're talking about those over 18, those under 18, those over 21, those under 21. So if we're going to go with gender here, because we're talking about a law that treats men and women differently, then we have to look at the handout here. So we know we're dealing with just the equal protection clause. So we know that anything related to gender, so like right here, that would receive intermediate scrutiny. So if we go over here, and this scenario, the government, so if you're a court, the government would have to prove that its actions are substantially related to an important goal or purpose. So at court, in this scenario, the government, let's see here, the state would have to prove that their law treating men and women differently. They would have to prove that that law is related to and substantially related. So like there's almost a direct link between them. an important goal or purpose. So they would say, yeah, it's important that we reduce DUIs. And this law, we base on evidence here showing that men are more likely to abuse alcohol and have DUIs than women. So we're making this law that's going to treat men and women differently. And then it would be your interpretation as a judge. You would interpret that law to be to decide whether or not it is substantially related to an important goal or purpose. So is limiting DUIs, is that an important goal or purpose? And are there actions to this law that treats two different groups differently? Is that substantially related to achieving that goal? So substantially related, important, those are vague words and they're subjective. So it's up to you, the judge or the justice, if this was the Supreme Court, it would be up to you to make that decision. Yes, it's substantially related, or yes, it's an important goal or purpose. So this is something, like I said, I don't think you're going to see on the exam. But here's another one. Number 2, the National Honor Society at a public high school bases admissions to the society on grades, service to the community, and character. The school tells an unmarried teenage girl that she was not selected because she is pregnant. The school claims her pregnancy does not reflect well in her character. So the two groups here, we have pregnant, not pregnant. So pregnant, not pregnant, we have to take a look at down here. So pregnant, not pregnant fits into the everything else category. So we would use the rational basis test, which means that the pregnant girl, she would have to prove in court, she would have to prove that the school was discriminating against her and violating her equal protection under the 14th Amendment. So rational basis is what we would use. So the decision would be that the government may use any means rationally related to a legitimate government goal or purpose. So we would have to decide, if we were the judges in the court or the justices, that is maintaining character, is that a legitimate goal of the school, and is barring a pregnant girl from the National Honor Society, is that related to maintaining character, if that is indeed a legitimate government goal? So you would have to decide what is legitimate if you were the judge or the justice, and you would also have to decide whether or not being pregnant and barring a pregnant girl from joining NHS, if that is related to maintaining character and whether or not character is a legitimate government goal. So that's how these equal protection cases work. They are up to interpretation. So just take a look through some of these, see if you can at least identify the two different groups, and then see if you can identify which level of scrutiny they would receive. I'm not collecting this. I don't think you're going to see anything relating to it on the AP exam. This is just an example of something that you would see in a college course about civil rights. If you were to take a law class relating to civil rights, you would see a lot of this. It's essentially a logic problem that a lot of this is like if-then statements. If age, then rational basis. If race, then strict scrutiny. So you can go through this. It's like a lot of things related to law are like logic problems. So if you liked logic problems in geometry, then you would probably really like making your way through like civil rights law. So like I said, I don't think you're going to see this. If you have any questions about it, you can ask me during our Zoom session, but I really wouldn't get too upset if you don't understand this. If you just know the basics, that race, religion, national origin are the most protected by the courts, and that kind of everything else is related to a lower standard of review. It doesn't mean necessarily that like you can't be discriminated against based on your age. I mean, yeah, I mean, discriminating against someone because of their age would be a violation of the 14th Amendment. But the difference is that you would have to prove that case. And it's assumed that whatever decision that the government made was correct, and that you have to prove discrimination. But if it's related to race or religion or national origin, the government would have to prove that they didn't do something wrong. So that's just kind of looking at how things would be framed in a court case. But like I said, I don't think you're going to see a lot of this, if at all, on the redesigned exam. So let's then go back to, well, let's take a look at a couple of other court cases that resulted from Brown v. Board of Education. So relating to the 14th Amendment, and this is where like strict scrutiny, intermediate scrutiny, rational basis, these were all created by the Supreme Court in a variety of different decisions. You do not need to know any of these cases by name for the AP exam. So Hernandez v. Texas from 1954. It was the same year as Brown. Actually, I think that is incorrect. I might have to go back and Google that. That comes later. Let's check that out. We're going to do a quick Google. Google with me. I think that's a typo because that has to come later. No, it was 1954. Okay, I was wrong. So 1954. This was applying the 14th Amendment. It's not related just to black and white. It can also be applied to national origin and ancestry. So that would be things like being Latino or Hispanic. Those are things that would also be protected by the 14th Amendment. Being Asian, being Italian or Polish, whatever it is, that your national origin and ancestry is protected by the 14th Amendment. And in the case Hernandez v. Texas, it was looking at a jury where Mr. Hernandez, the jury, he was convicted and his jury was all white. And he was saying, how can that be a jury of my peers if they are all white and I am Latino, I am, Mexican origin, and none of these people sitting on the jury are that. The case that created intermediate scrutiny protections for gender, Craig v. Boren, gender discrimination would receive something called intermediate scrutiny. And then later, so that case was from 1976. And then later in 2011, 2012, gender identity and sexual orientation were included as sexual discrimination by a U.S. Court of Appeals. The Supreme Court has never heard a case overturning that. So the assumption then is, and the application of the 14th Amendment is understood to mean that gender discrimination also includes sexual orientation, sexual identity. Marriage is another issue relating to civil rights that the 14th Amendment has been applied to. The case Loving v. Virginia from 1967, that anti-miscegenation laws, so laws that prohibit interracial marriage, that those were a violation of the Equal Protection Clause of the 14th Amendment. And then Obergefell v. Hodges in 2015, that the Loving standard was applied to same-sex marriage. So as a result of this, in 2015, the Supreme Court held that marriage is a fundamental right, and it's thus subject to strict scrutiny. So marriage receives the highest test. So if you're denying someone's right to get married, it receives the highest test in court. So marriage is a fundamental right in the United States, and it cannot be denied. So Loving v. Virginia, Obergefell v. Hodges are the two cases that establish that level of protection for that right. You do not need to know these cases by name for the AP exam, nor do you need to know these cases by name for the AP exam. That Hernandez v. Texas appeared last year on the SCOTUS FRQ. So if you were curious, if you want to Google the 2019 FRQs for the AP Gov exam, you could see Hernandez v. Texas compared to Brown v. Board of Education. And kind of walking through that logic, that separate is inherently unequal. Giving someone separate, distinct treatment in their criminal court, like their due process, their trial, that is indeed a violation of the 14th Amendment. So being felt and treated in a way so that you felt inferior. Craig v. Boren related to gender, and then of course these are the cases related to marriage. So practice again the civil rights law by looking at the equal protection assignment that I posted in modules, just to kind of get a feel for how the courts take a look at these rights as a matter of like legal understanding. And then we're going to take a look at civil rights and affirmative action in the next video. But these things, like I said, I really don't think that they're going to be on the redesigned exam. The redesigned exam that you're going to take this year online, it's 45 minutes, FRQs. I don't know what type of FRQ. I know that we're not going to see any multiple choice. And these cases may appear on a SCOTUS FRQ if you were to receive, or if that was one of the types of FRQs that you would see, but they would not necessarily ask you to explain like the levels of or the standards of review. That if you were doing a SCOTUS comparison, they would not ask you necessarily to talk about like strict scrutiny versus like rational basis. These would be things that you might see on a multiple choice test. And I think the only phrase that appears on the list, I have to go back and check. The only phrase is strict scrutiny. So if you know what strict scrutiny is, that's the highest level of protection for civil rights, where the government has to prove its actions are necessary, that its actions are necessary as part of a compelling governmental goal or purpose.